Hello everyone, welcome back to the channel. So today the video 4 of the NGT Act series, we are going to complete the rest of the chapters, that is chapter 4 and 5. So chapter 4 is about penalty and the first section is penalty for failure to comply with the orders, decision or award of the tribunal. So that person shall be punished with the imprisonment which may extend to 3 years and a fine which may extend to 10 crore rupees. So in case the failure or contravention continues even after the conviction for the first time, he shall be punished with additional fine which may extend to 25,000 rupees for each day. Okay, so if it is a company, then the fine may be extended to 25 crore rupees, and if the contravention continues even after the conviction, then with the additional fine which may extend to 1 lakh rupees for each day. So this has to be remembered. Okay, 3 years 10 crore rupees, additional fine is 25,000 per day, but in case of company it is 25 crore rupees, additional fine is 1 lakh per day. So then the second subclass says that notwithstanding anything contained in the CRPC, every offence which is mentioned under this act shall be deemed to be non-cognizable. Okay, so remember this, non-cognizable. Then section 27. So many times question arises, who will be held liable in case the environmental offence is committed by a company? So for this the answer is given in section 27, that is every person who was directly in charge of and was responsible to the company for the conduct of business of company will be held liable. Along with that person, the company itself will be held guilty. Okay, then the provided clause, the exception for this is provided that if that person who is responsible and directly in charge of the business is able to prove that this offence was committed without his knowledge, or that he had exercised all due negligence to prevent the commission of such offence, he will not be held liable. Okay, this is provided in the provided clause. In subsection 2 it is said that even though if that person is not directly in charge of that particular business or responsible to that particular business, but if it is proved that the offence was committed with the consent of that person or connivance of that person, or is attributable to any negligent act on that part, neglect act on that part, then these director, manager, secretary or other officer of the company can also be liable to be proceeded against and punished. Okay, that is what provided. So even if they are not directly in charge or responsible to the company, but if it is proved that it is the offense is committed with the consent or connivance or attributable to any neglect on the part of these members, then these officers can also be punished. Okay, then moving to the section 28. So the next section 28 answer to the question, what if the offence was committed by the government department? So it says that if the offence was committed by department of the government, and then the head of that department shall be deemed to be guilty. The same exception which is provided for the companies is provided here, that if the head of the department did all due diligence to prevent the commission of offence and the offence was committed without his knowledge, then he shall not be held liable. And in the subsection 2, this similar to that previous section, it is said that in apart from this head of department, in case any other person is involved in the commission of the offence with by giving consent, connivance or is attributable to any negligent neglect part on the officer, then such officer shall also be deemed to be guilty. This is what about the chapter 4. Okay, now moving to the chapter 5. Chapter 5 is about the miscellaneous provisions. The first section is 29. It says about the civil court bar, okay, civil court jurisdiction bar, and 30 is about the criminal court jurisdiction. So bar is like the civil court will not have any jurisdiction to entertain any appeal in respect of any matter which the tribunal is empowered, and also it cannot settle dispute or entertain any question relating to any a relief or a compensation claim or restitution of property damage or environment damage, which may be adjudicated by the tribunal. Okay, then moving to the criminal court's jurisdiction, it says that no court shall take cognizance unless upon a complaint made by the central government or any authority or officer authorized. Then the B is, even public can do it, but they should give a prior notice of not less than 60 days to the central government or authority of the intention to make a complaint about the alleged offence. Then in the subsection 2, it is said that no court inferior to the metropolitan magistrate or judicial magistrate of first class shall try any offence punishable under this act. So in case there is a criminal offence involved in the environmental related act, then the judicial magistrate of second class has no right to take cognizance of such offences. That is what given as metropolitan magistrate and judicial magistrate of first class. Inferior to these two magistrates, no one can take cognizance. Then moving to the section 31. Section 31 says that the member and staffs of the tribunal is also deemed to be the public servant under section 21 of the IPC. So remember this may be a question. So the 32 says that in case any person, employees of central government, state government or state statutory authority, or even the chairperson, judicial member, expert member of the tribunal, if acted on good faith and done something, it shall not be challenged. No suit or legal proceeding shall be taken against them. That is what section 32 is about, some immune powers. Okay, then 33 says that act have some overriding effect in case few acts are inconsistent with each other. Then 34 is about power to amend the schedule 1. Schedule 1 is about that 7 acts. In case the central government want to add few acts into that schedule 1, it can by notification amend the schedule 1. That is the power given in 34. Then 35 is about power to make rules. So there is a lot of power to make rules vested with the central government. Like they have given it in the subsection 2 and 3. There is no necessary to read all that things. Just remember the short title, that is section 35 is about the power to make rules. Then moving to the section 36 is about, we have already seen during schedule 3, it says amendment of certain enactments. So it should be amended in the manner specified therein. And 37 is about power to remove difficulties in giving effect to the provisions of this act. The central government can also publish it in the official gazette and make such provisions not inconsistent with the provisions of this act. These sections are not so important. Then 38 is about repeal and savings. Just forget it. Okay, so this is about the chapter 4 and 5, and we have covered only the very important part for the UGC net purpose. So go through it, go through all the 4 videos, and thank you. Subscribe for more videos.